Good morning, everyone. Welcome to Assembly Judiciary. We're going to get started right now, so I'm going to ask the secretary to please take the roll.
Assemblywoman Bilbray Axelrod.
Here.
Assemblywoman Cohen.
Here.
Assemblywoman Considine.
Present.
Assemblywoman Gallant.
Present.
Assemblyman Gray.
Present.
Assemblywoman Hanson.
Here.
Assemblywoman Hardy.
Here.
Assemblywoman LaRue Hatch.
Here.
Assemblywoman Marzola.
Here.
Assemblywoman Mosca.
Here.
Assemblywoman Newby.
Here.
Assemblyman Orentlicker.
Here.
Assemblywoman Summers Armstrong.
Present.
Assemblyman Urick.
Here.
Chair Miller.
Here. And with that, yep, looks like everyone's present. So today we have two presentations. Before we go into that, I just want to briefly cover a few housekeeping issues. As you know, let's see, please make sure you turn off your microphones when, I love to see everyone already here and ready to go. Look at that. They don't even need to be invited up. Perfect, I love that. So make sure, please, that you're turning your microphones on to speak and off to listen. We, of course, have viewers here in the room in Carson City. We also have people in Las Vegas and Grant Sawyer, and as well as I'd like to welcome everyone viewing online and on the website. If you have handouts for the committee, please provide 20 copies to the committee secretary prior to your testimony. In addition, exhibits and amendments must be submitted electronically as a PDF file to the committee manager no later than noon the day before the meeting. Committee information is available on Nellis through our legislature's website, and you can also watch through Nellis or on the legislature's YouTube. We will have public comment at the end of today's meeting, at which we ask that each person keeps it to 2 minutes, and that those comments are specific to those things that are under the purview of this committee. Written public comment can also be submitted up to 24 hours after the adjournment of this meeting. Again, I ask everyone to make sure that your cell phones are on silent or vibrate, and also our laptops as well. We want to make sure that our laptops that the volume's turned down as well. And again, just to remind everyone that while we're up here on the dais, please understand that members are researching and looking up things and accessing your presentation materials online. So please don't take that as a way of that we are distracted or doing something else. Yesterday, I did make a mistake, and I want to rectify that today, because what I forgot to do was to introduce our broadcasting staff. And broadcasting, we so fondly refer to them as BPS. They have been integral, especially through the pandemic, of ensuring that Nevadans have access to all of the work that's going on in the legislature by enabling people to actually call in and testify and make public comment on phone. So I would be really remiss not to introduce them. So with that, we have Star Linton, who is our control room supervisor, who, through interims, through the pandemic, has really just been the hero of access for our Nevadans. And of course, America Young, who is also our broadcast technician. So I apologize for not introducing you all yesterday. Again, as I mentioned, there's so many people that we don't see, but who are still vital to the operation of this legislature. With that, we'll go ahead and get started. We have two presentations today. The first one will be from the Department of Indigent Defense Services. And in my notes, I have that we have the executive director, the deputy director, the executive director, and 2 deputy directors, but I see that we have an additional person. So when you begin, if you could just, again, introduce yourselves, and something that I'm always working to remind myself, it's only been 4 sessions, but please make sure before you speak that you say and spell your name clearly, and especially with 4 people, as our staff is trying to get those minutes correct, to make sure that, especially with 4 people, to make sure that everything is accurate. We are ready when you are, so please proceed.
Chair, members of the committee, good morning. My name is Marcy Reba. Last name is spelled R-Y-B-A. Here with me today are my deputy directors, Thomas Qualls and Peter Handy. And we've also invited the Nevada State Public Defender, Chris Arabia, to be present. Moving into our presentation, just to give you a little bit of a roadmap, we'll all be taking an opportunity to tell you a little bit about our department, why we came about, what we're doing, introduce you to the State Public Defender again, and also introduce you a little bit to the Davis lawsuit and some concerns that our court-appointed monitor has with the stipulated consent judgment. Going into our presentation, I've provided here the vision, mission, and goals of our department, which you can read at your leisure. Here's the organizational chart of our department. As you can see, we have a very lean department. Our department sits under a board on indigent defense services. We have 2 management analysts, the 3 of us, along with 2 administrative staff. We also oversee the public defender, Chris Arabia. A little bit of background on why the Department of Indigent Defense Services came about. 60 years ago, the Supreme Court in Gideon v. Wainwright held that the Sixth Amendment to the United States Constitution guarantees the right to competent counsel to be provided. In the 70s, Nevada was a leader of indigent defense services by creating the Nevada State Public Defender's Office and providing those services to the rural counties. Washoe and Clark created their own public defender's office, which they're required to do by statute. At the time of the 70s, the funding structure was a little bit different, where the state funded about 75% and the counties picked up the remaining 25%. Over time, the funding structure shifted a little bit, and ultimately the counties were required to pay 75% of the costs, where the state paid 25%. Counties felt that they could provide services better and for a less expensive price, so they pulled away from the state public defender, and many of the counties either formed their own public defender offices, which are county offices, or they contracted with independent contractors to provide these services. Ultimately, the counties felt that this was a less expensive way than opting into the Nevada State Public Defender. Fast forward to 2018, the ACLU, in the Davis v. Nevada case, sued the state of Nevada, and they named plaintiffs in those rural counties where they contracted with indigent defense service providers as the plaintiffs. This was allowed to be a class action lawsuit, and they challenged the constitutionality of Nevada's practices regarding indigent defense systems in Nevada's rural counties, which were defined as Churchill, Douglas, Esmeralda, Eureka, Lander, Lincoln, Lyon, Mineral, Nye, and White Pine. And again, these are the counties that had pulled away from the public defender's office, and rather than forming a county public defender's office, had contracted with independent contractors to provide these defense services. To remedy this situation in 2019, the legislature created our Department of Indigent Defense Services in AB 81. This is now codified in NRS 180, and the department, or the legislature, placed us under the Board of Indigent Defense Services and told this board to create certain regulations and gave them rulemaking authority. Shortly thereafter, in 2020, a Davis stipulated consent judgment was signed wherein the state of Nevada agreed to comply with certain requirements on a certain time frame. And you can click the link to see the Davis stipulated consent judgment and what those requirements are. You'll hear through this later on in the presentation that we do have a court-appointed monitor in that Davis case, and she does have some concerns which we will present to you later in this presentation. With that, I would turn it to Peter Handy to discuss the programs that our department administers.
Good morning, Chair, committee members. Peter Handy, for the record, Handy, Deputy Director with the department. There's a long list you can see on the screen on this slide. I'm only going to hit a few of the highlights to kind of keep this brief and hopefully a little more detailed. So programs we administer, primarily we've been spending a lot of time serving as council administrator for rural counties. Currently, the department serves as a council administrator for 9 rural counties. This is pursuant to the passage of AB 480, where things like billing and selection of council have passed from Judiciary to the department. There are 6 counties that have local council administrators, so there's designees that sit in those counties and serve for those functions with the oversight and supervision of the department. We have selected counsel in more than 2,100 cases in 2022 and have reviewed requests for approval and approved more than 400 bills in trial cases and over 400 bills for post-conviction cases in 2022. I'm going to move down a little bit further to attorney oversight. So we provide ongoing review of attorney training, experience, and qualifications. So as part of the regulations that have been promulgated by the board pursuant to statute, we are required to ensure that all of the attorneys that are practicing indigent defense in the rural counties of Nevada are qualified to do so. So we have certain experiential requirements to ensure they have the correct amount of training, that they have the right amount of casework behind them and their experience to handle the kinds of cases that they're going to be handling wherever they might be practicing. So some attorneys are only qualified to handle misdemeanor cases, others are qualified to handle capital cases. We also provide comprehensive training to a lot of these attorneys, to all of these attorneys. We provide monthly trainings. We put on an annual conference for those attorneys and all the indigent defense practitioners in the state. Last year we held our first in-person conference with over 55 attendees. For reference, we manage a list of over 110 qualified attorneys, so half of those approximately showed up to our training. We also disseminate and receive client satisfaction surveys, so we provide to attorneys client satisfaction surveys to hand out to their clients. We then receive those back and then review those, try and see if we can see any trends in attorney practices. Moving down a little further, we provide legal server case management and data collection. So legal servers are a case management system. It's being utilized to collect data across all the rural counties for practitioners practicing indigent defense. If you're practicing indigent defense in those counties, you're required to use this system unless you've received some kind of waiver for some reason. This provides us with a lot of information, including caseloads, time that's being utilized by the attorneys in their caseloads, the amount of time being spent on certain case types, and we're trying to collect as much data as we can to kind of create trends, be able to try and predict either whether an individual attorney needs more training or more experience, whether attorneys in certain areas need more training experience, whether more funds need to be allocated to certain areas, or whether attorneys might be needed in certain areas to help cover increasing caseloads or workloads based on those increased amount of times. If I move on to the next slide here. Apparently I got ahead of myself because our annual training is mentioned again. I'll move on to the second one. So the maximum county contribution formula. I'm sure you've all heard a lot about this. So the department receives quarterly financial reporting from the counties based on what they've expended for indigent defense in that previous quarter. So over the last fiscal year, the department actually reimbursed over $1.9 million to the rural counties in Nevada, including Davis and non-Davis counties. And that's pursuant to this formula. So counties back in, I think it was 2017, 2018, after that, submitted their budget allocations to the department, and there was some math magic that happened. After the math magic, a cap was created. So it works kind of like a high deductible health insurance plan. Right now, counties have to spend a certain amount. Once they reach the cap for that amount, then the state starts reimbursing them for the expenditures they make for indigent defense programs. So in part of reviewing those quarterly reports, we're reviewing to see that they are actually making expenditures on indigent defense, that the funds aren't being spent in some other area. We're ensuring that it's being spent, how it's being spent, whether that's a contract attorney, whether that's a county office, whether it's on some other function like experts and investigators, or some other fees that are related to indigent defense. We do work with the counties proactively to remedy these situations. They've actually been very responsive over the last 6 or 7 months in getting us more detailed information. Some have even modified their accounting practices to give us better information backup for these reports. Systemic oversight, I'll talk a little bit about that. So we do review county indigent defense plans for provisions of indigent services. Those are required by statute to be provided. Previously, only Washoe and Clark were required to have those plans. After AB 81 was passed and our department created, all of those counties needed to start then producing plans. And right now, all 17 of Nevada's 17 counties have plans for provision of indigent defense services. We worked with all those counties to help not only build those, but also to improve those over time. We see those as continuing works in progress because as county needs change and indigent defense service needs change, those plans also need updating. We do work with counties to avoid corrective action. Corrective action would be if for some reason a county is failing to meet the standards for provision of indigent defense services, there is a mechanism by which the department would intervene, work with the county to change the system. So far, we haven't actually had to move to that step. The counties, again, have been very responsive in working with us to help avoid that kind of a situation. A few of the other things we're working on, developing pipelines and indigent defense services. As you probably know, like most professions in the state, Nevada is short on attorneys. Most of the state is what's considered a legal desert by the ABA, including Nevada's rural counties. So we're working with the Boyd School of Law to help develop and sustain law student to public defender pipeline. We've had a stipend program for this year and last year where 2 students from Boyd have been able to extern with a rural indigent defense office. They received stipends of $6,500 each to help cover their relocation and living costs to do that over the summers. We're also hosting interns or externs from Boyd during each term. We had 3 over last summer, 2 over the fall, and we have 2 legislative externs this semester. So far, they've been fantastic externs as well. If you know or are seeking any externs, I would look to the Boyd School of Law. We're also providing grants application and management. We do have kind of limited resources for this. Right now, we're managing 3 grants, the first being that grant that provided the stipend to law students practicing the rules. That was provided by the State Bar of Nevada. We're also administering the Byrne JAG grant. That's a sub-grant that's administered by the Department of Public Safety, and that's to help rural attorneys attend our annual conference. We're also administering the John R. Justice grant, JRJ, whereby we can help repay some attorneys for some student loan costs that they have incurred. It's a difficult process for us to manage because we do have those 3 grants. It's a lot. They require pretty frequent reporting, new applications every year, or program modifications or extensions, and the 3 of us are lawyers. We're not really finance people. In addition to those duties, Marcy serves as secretary for the Board on Indigent Defense Services. We do work with them to prepare their meetings. We work with them to ensure that all of their needs are met. And in addition to that, we maintain the website and do other administrative tasks, building the department budget, taking phone calls, everything else that needs to be done by a department. I'll move on to some of the department's achievements. So as I mentioned earlier, all 17 counties have created and approved plans for the provision of indigent defense services. It's the first time in state's history, and again, since AB 81, these are all requirement. Again, the counties were very helpful in working with us to get these plans actually finalized and delivered. Fiscal reporting reimbursements or requests. Again, the department received annual fiscal reports from all 17 counties, and we were able to obtain reimbursement through IFC and the set-aside in Section 80 last session of over $1.9 million to those several counties. We've implemented AB 480. Again, we serve as a council administrator in 9 counties, have council administrators, local council administrators in 6 of those counties. Again, the department's sitting in the shoes of judges, really, for a lot of those situations. So we are reviewing what's happening in individual attorneys' cases when they're seeking experts and investigators to ensure that those are reasonable and necessary costs being incurred by the counties or ultimately the state, depending on where their costs are at for the year. And we provide continued training and resources. We held our first in-person training networking conference in Las Vegas. That was May 26th, 27th of last year. We had over 55 providers attend. We're planning on hosting that again. This year it'll be in Reno, May 3rd through 4th. You're welcome to attend if you're interested. Legal server and uniform data collection. We rolled out case management software, I think it was in 2021 when it was actually first rolled out, and we provided thorough training and technical support to all indigent defense providers in the 15 rural counties. This is how we build our quarterly and annual reports and publish our data on our website. Again, the board produced permanent regulations on the indigent defense services, and those were adopted by the Legislative Commission in October of 2021. And there's a link to those regulations on that page if you're interested in taking a look at them. Now I get the pleasure of introducing the new State Public Defender of Nevada, Chris Arabia.
Good morning, Chair, committee members. My name is Chris Arabia. I'm the newly appointed State Public Defender, and just to give you a very brief overview of what we do, we currently provide all indigent services for Carson City and Story County. At full staffing, we would have 9 attorneys. We're 3 short right now, 2 investigators and 4 administrative staff. It's kind of an exciting time for the office. Over the next 2 fiscal years, we're going to be expanding. We will be providing all indigent services in White Pine County, and we're also going to be launching a complex litigation team, which is a fancy way of saying we'll be responsible for death penalty representation in Churchill, Humboldt, and Lander counties. We will be providing appellate representation for Esmeralda, Humboldt, Lander, and Lincoln counties, and providing pardons and parole representation for Churchill, Esmeralda, Humboldt, Lincoln, and Lyon. And I can say that I'm excited to be here, and I'm looking forward to improving the quality of indigent defense services. Thank you.
Morning, Chair and committee members. My name is Tom Qualls, Qualls. I'm one of the deputy directors at the department. I just want to talk to you for a minute about some of the Davis monitor's comments. As we discussed, there is a court-appointed monitor to ensure that all of the requirements in the Davis stipulated consent judgment are being accomplished and complied with by the department. So the monitor produces a quarterly report. We check in with her regularly. We send her oversight reports from the road, as well as reports on, everything from our data collection to surveys that we do regularly of our attorneys and the counties. I would note that all of the accomplishments that Mr. Handy discussed, virtually the entire history of our department has been during the pandemic. So with our very tight staff and under very unusual circumstances, we were essentially launched and have done all of the team building that we've done across the state and complied with Davis to the extent possible. To the extent that it's not been possible, I will discuss these three current challenges that the Davis Monitor basically consistently names, and these particular ones are from her latest 6 report. So the first one is insufficient department budget for oversight and overfunctions. We are tasked with boots on the ground oversight of the 15 rural counties in Nevada. Right now, and historically, again, with the restrictions of COVID, it's been Ms. Reba and myself on the road, in addition to doing all of the higher level policy work and day-to-day running of the department. We have limited travel budget, and so we have visited all of the counties, again, doing face-to-face team building, working on building these plans, inspecting courthouses, inspecting jails, making sure that there's places for attorneys and clients to meet, oversee or observing court proceedings, etc. But it's pretty much impossible for us to do the kind of oversight that Davis mandates with just the two of us. So that's a concern of the monitor. She notes that there's insufficient staff for adequate oversight and annual reviews, and insufficient funding for required support, training, and mentorship of certain attorneys. Her proposed solution is to increase the department staff to include policy analysts, oversight positions, and additional funding. The second challenge noted by the Davis Monitor has to do with workload standards and the insufficient number of qualified attorneys. You may know, as been discussed here today, that there is a shortage of indigent defense attorneys in the state, primarily in the rurals. This is not actually unique to Nevada. This is happening in a number of different states. It largely has to do with unsustainable caseloads and low pay. Different states are creating different solutions to this problem. Additionally, the only caseload workload standard that we have to go off right now is from the ABA, which is from the 1970s, so it's about 50 years old. The RAND Corporation has been working on for some time an updated workload standard. To our understanding, it was completed sometime around June of last year, but has been in peer review since then. We have contracted, as required by the Davis case, with the National Center for State Courts to conduct our own workload caseload study. It was informed by a number of different things. The first one is our caseload management system, which we rolled out to collect data from all of the counties. Never before have we had any kind of data in Nevada on caseloads and workloads from any of these counties. So that, and then they conducted what's called a Delphi study, which is long interviews with practitioners in the field in various different categories over a long period of time. And then they are currently waiting for the RAND study to be released so that they can incorporate that into these findings. Once we have that study released, the counties actually, under the Davis case, have 12 months to standards, which is in practical terms going to look like fairly dramatic increases in the number of indigent defense attorneys in each of these counties. And again, we're sort of in that position where there's already a shortage. So we're working with the counties to build sustainable and effective solutions to these, including pay parity with prosecutors and bringing the levels of salaries and contract amounts up to an amount that will attract qualified attorneys and again make these systems more sustainable. Mr. Arabia pointed out earlier that his office is down 33% right now in attorneys, and that has in part to do with the fact that the state public defender attorney salaries are not very competitive right now. This is not something that any of you don't know. I'm sure that this is a repeated complaint in departments across the board. So, in short, the solutions that she recommends are public defender pay parity with prosecutors, increased hourly rates under NRS 7125. That's for individual appointed conflict counsel, and to ensure that our department and the Nevada State Public Defender is adequately funded. The last challenge, as noted by the Davis Monitor, has to do with the maximum contribution funding that we've discussed also today. To recap, the counties have a cap on what they have to pay on indigent defense services, and over that, the state is required to reimburse them. The way it worked in the last session is that the money is not in the department's budget, so we have to go through interim finance committee to request those funds. There's a delay in doing that of 2 to 3 months after the counties have spent this money and then reported to us, and then we get to go before the committee. Again, takes a lot of time and resources, takes up a lot of time and resources of you find people. And so the monitor suggests that this money be put into our department so that we can more efficiently handle this and the counties can receive their disbursements in a more timely manner. With that, I'll turn it back over to Ms. Reba to discuss Senate Bill 39.
And just shortly, Senate Bill 39, this is our policy request that we've submitted, and we will be introducing this tomorrow at the Senate Judiciary Committee. And the purpose of this, you've heard that we're doing that council administrator position for a lot of the counties. And when they ask for experts and investigators, we need to find out if it's reasonable and necessary. So we are asking them to let us know a little bit of their thinking, write down why it's necessary for their case, and we want to make sure that that's protected. We want to make sure that we maintain that attorney-client privilege and that an individual couldn't request those records from our department to try and see what the public defenders are asking for and why they're asking for it. They're also required under Davis, as well as our regulations, to provide data, and the attorneys have expressed concern that the names of their clients that are coming over in our case management system, they want to make sure that attorney-client privilege is protected. So we did submit Senate Bill 39 as our policy request. And with that, we would take any questions.
Thank you for that presentation. I will just give members a moment to request any questions they may have. We will start questions with Assemblyman Orlichter.
Thank you, Chair, and thank you for this presentation. And I'm glad to hear our Boyd students are doing such a good job. So thanks for that. Do other states have funding policies that are more sustainable? What do others, maybe no state, but is there a model out there for how you raise funds for this, whether it's a fee that lawyers pay as part of their admission to the renewing their bar, or some other way to make sure this is not a chronic problem?
Chair, Assemblyman Orlichter, this is Marcy Reba for the record. And I think when you look at what each state is doing, each state has their own way of providing resources to indigent defense services. Some are charging attorneys and taking funds from maybe IOLTA accounts to help support indigent defense services. Some are coming from general fund, and it just depends state by state how the state is set up. The state of Nevada is very specific because the legislature set forth a requirement that our board create that maximum contribution formula. So the legislature said you need to almost do like this high insurance health care where the counties pay up to a certain amount, and after that point, the remainder is reimbursable by the general fund. When we look to any other state that is comparable to that, we couldn't find any other state that has a maximum contribution formula. But there is a mixture. Some is 100% state funded, some is county funded, and some are a mixture like the state of Nevada is.
Thank you. Executive Director Reba, because these presentations are also educational for the members, and in every committee we use so many acronyms and so much jargon that we assume everyone understands. Can you just briefly, in 2 or 3 sentences, explain what an IOLTA account is to everyone?
Chair, I'm sorry. Yes, an IOLTA.
See the head nodding? Yes. What is an IOLTA?
An IOLTA account is where private attorneys have to take funds when they've taken on new clients and put them into a separate account. This is an interest-bearing account, and that interest goes to, the state bar to be used for certain resources. It's not kept with the attorney as a way to be able to, arguably make additional funding off those amounts.
And am I correct in adding from my previous banking days that interest is what actually helps pay for the public defenders when someone needs, is that what the interest is doing?
In the state
Or
of
is it just going to, continue?
Sorry, Chair. In the state of Nevada, Marcy Reba for the record, that IOLTA account goes to the state bar to administer, and those funds are going to civil appointments, pro bono appointments, to be able to reimburse those. They do not go to indigent defense services.
Right, they go for the public defender.
Not,
No, it does not. Okay.
Not the public defender.
For the public defense.
If I could jump in real quick,
Yeah.
Peter Handy for the record. So these are interest on lawyer trust accounts. That's what the acronym is. So these are funds that are held in trust by attorneys for their clients to be used in paying perhaps later. The interest from these accounts then gets deposited into a fund that's specifically earmarked for, I think it's corporations that are under the Legal Services Corporation. So 501c3 entities, things like Nevada Legal Services. Those are the recipient of those funds.
Perfect, thank you. Next, we have a question from Assemblywoman Summers Armstrong.
Thank you, Madam Chair, and thank you all for this very enlightening presentation. I have a 2-part question. One, you spoke specifically about the parity between public defenders' pay and prosecutor pay. So I have 2 questions. One, what is the difference? And also, what are the current staffing levels between, comparatively between them, so that we can get an idea of why we can't seem to keep public defenders?
Thank you, Assemblywoman Summers Armstrong. Tom Qualls for the record. I can answer at least part of that question. Public defenders represent indigent persons who are charged with crimes, anything from a misdemeanor to a high-level felony. And a prosecutor is like a district attorney who brings that case on behalf of the city or county or state to prosecute those crimes. So In a perfect world, that's a level playing field because you've got advocates in the same case on kind of what we say opposite sides of the V, right, in the case. And the resources, the salaries, the resources, the access to investigators and experts ought to be the same and on parity so that you have equal justice.
And Chair, committee members, Marcy Reba for the record, I can answer the other part of that question as to what are the prosecutor salaries that are across from the state public defender at this point in time. As Mr. Arabia said, the state public defender provides those services in Carson City. And although on paper the deputy district attorney looks on par with what our public defenders make in the area of about 102 to 107, we've done a data study where our data analyst has pointed out that state employees are required to contribute 15.5% of their salary to PERS, where at the county level they are not required to make that contribution, and the county makes that contribution for them. Another area that we've seen disparity is as we've gone up to the chief and the leadership in the prosecutor's offices. The chief deputy district attorney in Carson City makes up to $156,000. A chief at the state public defender's office makes up to $120,000. The assistant district attorney in Carson City makes $184,000. The state public defender makes $133,000. So that shows a distinction. We're also seeing a distinction even between the Attorney General's office and our department. For example, the Attorney General's office has something called a Senior Deputy Public Defender that allows for growth within it's a Senior Deputy Attorney General, and this allows for growth within the Attorney General's office, allows individuals that have been there for a long time to move up to that senior level, and that increases their pay salary to up to $120,344, which is similar to our chief. But the distinction is that when you look at the forms on what type of work is required for that reporting, you can see that our chief is required to do administrative work, where the senior attorney general is just listed as a professional. So there's additional duties that are required to be put forth by our public defenders in that chief position. And actually the chief deputy attorney general makes the same as what our Nevada State Public Defender makes, even though they don't have that statewide representation that Mr. Arabia is required to start. Once counties start opting in, he will be required to set up those offices in any counties that would like it and provide that oversight. So we have a compensation analysis and recommendations that was done by a data analyst that's on our website, and I could also provide that to you if you'd like to see that.
We would appreciate that. Please submit it to the committee. Thank you. And we're going to move on. We have other questions? Oh, we're going to move on right now. If you could submit that as well to us, we'd appreciate that. We have a question from Assemblywoman Hardy.
Thank you, Chair, and thank you for the presentation. I have to say that's a statement we probably don't think we would hear very often, that we don't have enough attorneys. We always say, we don't need any more attorneys, please. So my question is regarding the caseloads that you mentioned. If you wouldn't mind sharing kind of what the current caseloads are. Now I know they're going to be dramatically different for, say, rural as compared to Clark and Washoe. But if you could kind of share what their caseloads are currently, and then what the current recommendations are to kind of compare. And then obviously they're going to change when you come out with the new reports, but I'd be interested to know those. Thank you.
Chair, Assemblywoman, we publish caseloads on a quarterly basis, so we can provide you copies of those. We do not actually collect data for caseloads for Washoe and Clark. At this point in time, they are excluded because the focus on our data collection has been in the rural counties. We also have not set a workload other than what's set forth in the Sixth Amendment, that you need to be able to provide competent representation for your client. And if you feel that you're not able to do so because of your workload, you should be withdrawing. Once our weighted caseload is released, which we hope to be released this year, counties will have within 12 months to be able to comply with that and have the appropriate number of attorneys for the appropriate cases. And the distinction in the rurals is it's not just cases, it's travel time. You know, some of these courts are so far away. Esmeralda, getting to Goldfield. Tom and I had a very interesting experience where we drove to Goldfield and we left to go see a court in Tonopah, and 2 semis jackknife and closed the road, and no one else could get out of Goldfield after that. So there's these little specifics for the rural counties that we are hoping to take into consideration in our workload of, you know, if you live in a larger county, you have traffic and other things to get to court, but you don't have hours on the road to be able to get to where your client is. So our workload, once it's published, we'll take that into consideration, and it won't just be numbers of cases, it will be travel time that's required as well.
And with that, I'd also like to ask, because I assume most of us assume, well, what about electronically that we can communicate, but then we have the connectivity issues out in some of our remote rural areas as well. Is that correct?
Thank you, Chair. Yes, Tom Qualls for the record. Fortunately, all of the rural counties have virtual court capabilities. You know, it's one of the things that the pandemic gave us, and most of them are very accommodating, especially for the newly enacted 48-hour initial appearance hearings. They allow those, especially on the weekends and holidays, to be virtual. There are a lot of rural courts where if it's not a substantial hearing, they will allow virtual court. And there is, right now, there's a committee that is working on, I think, a statewide standard or a statewide administrative order from the Supreme Court regarding what hearings are going to be allowed to be virtual and which ones are not. So that does ameliorate some of the travel time. But again, there are many instances in which the contract public defender in Tonopah, say, has to drive from Vegas to Tonopah at least weekly for hearings.
Okay, thank you. We have a question from Assemblywoman Cohen.
Thank you, Chair, and thank you for the presentation. I actually was going to ask about virtual hearings, but since you've answered that, can you talk about the virtual accessibility with your clients who are in the jails and the prisons? Are they being accommodating for you?
Chair, committee members, Marcy Reba for the record. Again, this is county by county. It is up to the jail with how they provide these resources. But in our understanding, the rural counties are very open to having any sort of access that is possible, so long as it has been budgeted. We've heard from some White Pine County public defenders that actually bought an iPad and brought it over to the jail during COVID so they could communicate with their clients, and they had a lot of success in that. Others haven't been able to communicate and are limited to telephone. But some of these rural counties are doing a great job with the virtual appearances in court. You know, they set up different rooms where the clients can confer with their attorneys, and then they'll be entered into the courtroom so they have that attorney-client privilege time. But again, it's run by the sheriff as to what access they provide there, but we haven't necessarily heard that individuals are not allowed to contact their clients as freely as they would like.
Our next question is from Assemblyman Gray.
Thank you, Madam Chair. Just wondering, you may have touched on it earlier, but has there been any thought given to like the rurals coming up with an indigent defense office amongst, 3 or 4 counties where they could at least pool resources? It won't affect the caseload, but I mean, it'd be one office, multiple attorneys. I mean, just one easier location to manage and in-depth assistance. Because I know, like in my home county, and it would just be hard to even get more office space at this point for another attorney, much less attract somebody to Urington, so to speak.
Chair, committee, Marcy Reba for the record. If you read our regulations, counties are allowed to put joint plans for the provision of indigent defense services and enter into these plans together and share office space. No counties have chosen to do that, even though it's been offered to them. A possibility that would be similar to that would be the Nevada State Public Defender. Every county can opt into the representation of the Nevada State Public Defender, and it's automatic. Once a county opts in, the State Public Defender has to provide those resources for that county in that next biennium. And that's why we're seeing White Pine come into the State Public Defender's representation.
If I could just add to that, Chair, Tom Quells, for the record. Additionally, we're working on making sure that there are offices in all of the places that there need to be offices. For instance, we're working with Story County right now to get space for a public defender office up there, because right now the situation is if you have a trial or any kind of substantial hearing there, you've essentially got to travel from Carson City, where the state public defender's office is, back up there. Clients are not able to come to an office in Story County and meet with the attorney, so you're forced to talk to them in the courthouse. And again, there's no computers, there's no printer, there's no ability to do the things that are necessary. So we'd actually like to see more offices and more places for accessibility and for purposes of attorney-client communications.
Thank you. And with that, I don't see any more questions from members, so I'd like to thank all four of you for this presentation. And again, when you're able to submit those responses. Thank you so much.
Thank you.
Our next presentation will be from the Cannabis Compliance Board, and we have Tyler Klimas, the Executive Director, who will be presenting on the Cannabis Compliance Board. Yeah, I know. So we'll just give you a few minutes, and then whenever you're ready, please proceed. Also, as well, I only had the executive director listed, so please make sure everyone state your name and your title before you begin.
All right, thank you, Chair, members of the committee. My name is Tyler Klimas, Klimas. I'm the Executive Director of the Nevada Cannabis Compliance Board. I'll take the opportunity now to introduce my incredible team that is with me. To my right is Deputy Director Michael Miles. To the left is Chief Kara Cronkite over audits and inspections. I'd also like to point out behind me is Chief David Staley of Investigations, Chief Steve Gilbert of Admin and Licensing, and Tiana Bonner, our Public Information Officer. So we appreciate the opportunity to be here today to give you a little overview of the Cannabis Compliance Board, our operations, what we do, and then answer any questions that the committee may have for us. We have a presentation, and so we'll go ahead and move on to that. That's the slides. That's perfect. This is possibly one of the most important slides for us. In 2019, the Nevada Legislature set forth the public policy that would ultimately guide our agency in all of our operations. We take this public policy very seriously, as it dictates how we perform our duties, our regulatory decisions, and ultimately our core mission and purpose.
You'll see here on this slide that the legislature at the time recognized that the continued growth and success of the cannabis industry is dependent upon public confidence and trust, two words that are also very important to the CCB. And that public confidence and trust can only be maintained by strict regulation of all persons, location, practices, associations, and activities related to the operation of cannabis establishments. This is all in state law. If this language is familiar, it is because it is taken almost verbatim from the same public policy that guides Nevada's gold standard gaming regulation and oversight. The CCB was created to mimic that same regulatory oversight that we have for gaming, but for the cannabis industry, and for the same reasons. So you see at the top here, our mission statement reflects those same principles. The CCB and its responsibilities oversees Nevada's 760 medical and adult use operational licenses. We enforce statutes and regulations that guide the industry, and we focus many of our efforts on what may be our most important responsibility, which is to protect the public health and safety of our many medical patients, adult use consumers, residents, communities, and visitors to our state. Our agency is managed by a 5-member part-time board, currently chaired by former Nevada Supreme Court Chief Justice Michael Douglas. We hold monthly board meetings where the board presides over disciplinary matters, licensing approvals, management service agreements, or new or revised regulations, among other things. The CCB prides itself on accountability and transparency, and through our public meetings, we encourage robust public participation and engagement. Our agency has 93 full-time employees, and we have 4 divisions within the agency: administration and licensing, inspections and audit, investigations, and enforcement. Also created alongside the CCB was the Cannabis Advisory Commission, which I chair in my position as executive director. This commission is made up of 12 members and is designed to mimic the Nevada Gaming Policy Committee. Therefore, the commission meets at the request of the board, the governor, or the legislature to study cannabis-related issues when they come up and make recommendations to the board at its request. The most recent example of this was around consumption lounges, which passed last legislative session. Agency growth: when we were first authorized in July of 2020, we had 50 full-time employees. Since then, our agency has continued to grow now into the 93 full-time staff we have currently authorized. Along the way, we've identified many operational efficiencies and addressed many issues that plagued the previous oversight body, working to automate much of what we do, and through reconfiguration of resources and functions, work through all of the backlogs we inherited or that were created as a result of the transfer of oversight responsibilities. This slide gives you a snapshot of our distribution of licenses, as well as some other facts on license holders, agent cards, and the types of facilities that we regulate: cultivation, production, laboratories, distribution, retail dispensaries, and now, or soon-to-be, consumption lounges. You'll see we have over 18,000 active cannabis agent registration card holders in the state. Some information on taxable sales and tax collection. You'll see information and sales data spanning the last 3 fiscal years. This is the first year since cannabis was legalized in Nevada for adult use that we have seen a decline in yearly sales. We're down about 4.5% fiscal year over fiscal year, and about 14.5% calendar year to calendar year. This trend is consistent with more mature cannabis marketplaces across the nation, and is a result of a number of market dynamics. For one, we had been experiencing extreme year-over-year growth since 2018 when we legalized adult use. The numbers were always going to stabilize at some point and begin to provide us a baseline, and then the pandemic hit. People were at home, people received stimulus money and had sizable discretionary income, and we saw an almost 50% increase in sales from 20 to 21. So now today we are coming back to earth a little bit. The pandemic restrictions are ending. People are back at work. Discretionary income is falling as inflation continues to affect the economy. We have competition from the illicit market. So again, what we're seeing in Nevada is consistent with what our counterparts are seeing in other states. If anything, given our tourism economy, our prices have not fallen as much as some of the other states, at least not so far. Our agency is funded a little uniquely. We do not take any general fund money. We are fee and tax funded, with the remainder what is deposited into our account transferred to the state education fund. As you can see, this past fiscal year, we generated just over $8 million in licensing fees, time and effort assessments, agent registration fees, and fines and civil penalties. There was also just over $63 million collected from the 15% wholesale tax. That wholesale tax money is then combined with our agency-generated revenue, and from there, we take care of our operations. We send $5 million to the local governments, we send $250,000 to the health division, and then transfer the remaining balance to the state education fund. This fiscal year, it resulted in just under $59 million transferred. Now, for your awareness, that $59 million is not the only revenue stream from cannabis that flows to the education fund. There's also a 10% retail tax on cannabis sales at the retail level. That amount also goes into the state education fund in its entirety, but does not pass through the CCB. So in the most recent fiscal year, the state collected over $89 million in that retail tax. That plus the 59 combined for a $147 million transfer, all in to the state education fund for fiscal year 22. Also important to note here, the CCB does not handle tax collection on the wholesale or retail side. That duty is the responsibility of the Department of Taxation. So next I'll highlight our 4 divisions briefly to give you an idea of what we do. The first division is administration and licensing. Admin maintains our database of all license holders and ownership records. It processes and reviews all license applications and renewals and collects all related fees. This division also is in charge of managing the Cannabis Agent Registration Card Program, which, through the efforts of the Admin and Licensing Division, has seen a reduction in wait time for agent cards by over 98%. Processing new cards for industry employees in the industry used to take up to 45 days and now takes 1 business day. Administration also works closely with the Department of Public Safety and the FBI on agent card background checks, as well as the Department of Taxation on collecting unpaid taxes and fees. Recently, we successfully facilitated the first licensing round for consumption lounges in Nevada. This was a significant accomplishment both for the CCB and the state because there had not been a licensing round in Nevada since 2018, which, if you remember, was highly litigated. It is still going on in the courts and nearly brought this industry to a standstill. We implemented a random selection process for this round, which allowed us to hold a randomized drawing for licenses at a public event to ensure total accountability and transparency of the licensing round. This licensing round was also the first time that the state allowed for individuals who were not already in the industry to apply for a cannabis license. Up until this point, all licensing rounds prior applied only to those who already had cannabis establishments. Furthermore, this licensing round facilitated Nevada's first ever social equity licenses. This was a component of Assembly Bill 341 from last session. 10 lounge licenses were available only to those individuals who were deemed to have been negatively impacted by prior drug policy. This is the first step and a very significant step towards greater equity and inclusion in the cannabis industry in our state. The Inspections and Audit Division agents visit all Nevada's cannabis licensees at least once a year, and in many cases more than that, to perform routine audits of inventory and inspections of facilities. Inspection and audit agents also conduct pre-opening inspections, facility modifications, and spot checks, usually around major holidays and events. CCB inspection and audit agents ensure facilities and establishments remain in compliance with rules and regulations. They track all inventory from facilities through Metric, which is our seed-to-sale tracking system, and they also inspect Nevada's 10 testing laboratories to ensure laboratory standards and appropriate procedures are being followed. When our agents finish an audit or inspection, they either issue a statement of deficiency or a statement of no deficiencies, depending on the result of the inspection or audit. As you can see, in calendar year 2022, out of 427 notices issued, we had about 56% received statements of deficiencies, which means we identified violations or instances of noncompliance. About 44% received statement of no deficiencies, which means it was a clean audit or inspection with no compliant issues found. So roughly half of our inspection and audits in a given calendar year have no compliance issues to report on. That's a good thing. We'd like to see that number grow. Now, just because you receive a statement of deficiency does not mean you'll be fined or a complaint will be filed. Many times these are minor deficiencies that can be corrected by submitting back to the CCB agents a plan of correction, which we review and approve. When a violation does rise to the level of potential disciplinary action, we transmit the details of the violation to the Attorney General's office. They review the case and they recommend back to us either to proceed with the complaint or not. Only at that point, and if the Attorney General's office agrees with our recommendation, do we then proceed with disciplinary action. As you can see, there were 23 complaints authorized by CCB board members in 2022, as a result of violations identified. So out of 427 audit inspection notices in calendar year 2022, the board authorized 23 complaints. Recently, and of note, the CCB introduced what we call letters of concern. This provides our agency with a tool that sits somewhere in between a statement of deficiency and a complaint. It allows us to issue an official letter in lieu of a disciplinary complaint, and it serves as sort of an informal warning that doesn't come with an official complaint or financial penalty. This process has allowed us to provide an extra layer of education with the industry to address a violation before such conduct escalates to a disciplinary complaint. Additionally, the CCB and the Attorney General's Office take into account self-reporting as a mitigating factor in our disciplinary process. These mitigating factors are usually noted in any settlement agreement and presented as part of that settlement agreement to the board before the board approves any final action. These settlement agreements are also posted online for the public to view. Now, we receive hundreds of self-reporting incidents every year, and multiple on a daily basis. Most don't rise to a disciplinary level, especially if the licensees take immediate action. In fact, there's only been a few cases, exactly 5 cases in our history as an agency, so in 2.5 years, that a self-reporting violation did result in a disciplinary action or financial penalty. Those cases, however, dealt with subject matter that this board, along with the United States Department of Justice, consider to be the most important pillars of keeping a safe and effective industry that remains free from any potential federal intervention. That includes sales to a minor, diversion of cannabis out of a facility, and hidden ownership, which has potential to invite criminal elements into our industry. 3 of the 5 self-reporting incidents that have resulted in a fine dealt with one of those topics and carried a significant financial penalty as a result. The other 2 dealt with selling more product than what is allowed to a single consumer in a transaction, and although we consider that a serious issue, they were subsequently pled down to a financial penalty significantly lower than what could have been assessed. Again, all of these actions are decided at a public meeting, are totally transparent, and are posted online for anyone to view. Moving on to our investigations division, our investigators are tasked with processing all transfers of interest. These are sales of licenses to new owners, or if a licensee sells a percentage of ownership to new or existing owners. This process includes a complete vetting of all potential new licensees and affiliated owners, officers, and board members. It includes sit-down interviews with applicants and a full suite of background checks and financial analysis on potential entrants into our industry. This process was modeled after how the Gaming Control Board vets potential licensees in the gaming industry. The CCB Investigations Division has been a large success, especially in efforts to uncover hidden ownership and to ensure we know exactly who is in our cannabis industry. The results of these investigations are presented in public to the board, and potential and current licensees must appear in front of the board to answer questions about the vetted transaction. CCB agents have uncovered a number of instances of hidden ownership within the industry, along with potential bad actors and individuals unsuitable to participate. Finally, the CCB's small but mighty enforcement division is made up of 8 post-certified enforcement officers. In addition to supporting complicated and/or contentious facility inspections, our enforcement agents investigate criminal complaints, as well as participate in multi-agency law enforcement actions to address illicit market activity like outdoor cultivation sites and illegal sales of cannabis. The CCB hosts quarterly law enforcement meetings where we invite all local, state, and federal law enforcement agencies in a closed-door meeting to discuss cannabis-related issues and share operational opportunities and challenges. And so that completes the rundown of our agencies. This legislative session, we have 3 bills that we're carrying that will eventually, I believe, come before this committee. Mostly housekeeping in nature. Senate Bill 31 authorizes cannabis establishments to move jurisdictions outside of Clark and Washoe if they receive approval of the receiving local government. Senate Bill 33 is a very large housekeeping bill that cleans up a number of provisions contained in Title 56 of the NRS now that we've had a couple years to live in those statutes. And finally, Senate Bill 69 creates another tool for CCB agents to address smaller violations, as well as memorialize the disciplinary process that the board is currently utilizing by further involving the CCB's administrative law judge into our hearing process. Some additional thoughts to consider: challenges that we see for this year. As discussed, sales are down and tax revenue is down. Federal inaction on cannabis-related matters continues to hamper both regulators and the industry. Limited access to banking keeps the industry, or at least a percentage of the industry, all cash-based. Federal tax code also continues to prohibit certain tax write-offs for cannabis businesses. This increases overhead costs and places an additional economic strain on these businesses. And additionally, there's just this constant threat or possibility of federal action to reschedule or legalize cannabis at the federal level. We know it's coming, we just don't know when it's coming, but obviously that would significantly change the landscape of the marketplace here and across the nation. And finally, looking ahead, we'll start to see consumption lounges open likely towards the end of this year and into next year. We're also commissioning a market study that will review and analyze our cannabis marketplace, including examining supply and demand, any need for new licenses of all license types, as well as try to analyze the breadth and scope of the illicit market here in our state. So with that, Chair, thank you for the opportunity to be here. My staff and myself are here to answer any questions that the committee has. Thank you.
Thank you for that presentation. Our first question is from Assemblywoman Bilbray Axelrod.
Thank you, Chair, and thank you for being here this morning. My question is really about the unlicensed businesses. I'm floored when I see billboards that are clearly blatantly unlicensed, and I'm just wondering, are you guys collecting civil fines, anything that from these businesses, and to that end, are you in the governor's budget, are you asking for staff members specifically for that? Because I see that as being one of the biggest issues, quite frankly.
Thank you, Assemblywoman, for the question. Tyler Klimas, for the record, and you're absolutely right. I mean, again, and I said it, this is the greatest competitor to our licensed market is the unregulated market. And it's not specific to Nevada. It's every state that has a legalized marketplace. There was this common thought that, you legalize cannabis for adult use, and it's automatically going to squash the illicit market, right? Because people can go buy it legally. Well, that didn't happen. It didn't happen anywhere. If anything, it grew the illicit market in some way. They've got a smokescreen to hide behind in a way. So we are seeing billboards, yes. We see illegal delivery operators, which are really hard to distinguish between a licensed delivery operator. I think there is some greater coordination needed around the prosecution side of this. We are working, and I think we're doing a lot better now coordinating with state and local law enforcement. Again, we implemented this quarterly meeting, so these are the discussions that we're having. But yes, I think resources are needed across the board. But again, we have to have these conversations about, how we're going to move forward in prosecuting this, because we can find them, not find them, but find them with a D. We can identify some illegal operations, but we need that last piece. We have had some additional conversations with the Attorney General's office, some very productive conversations about potentially proceeding with some prosecution on some of the CBD and Delta-8 issues that we're seeing. That's basically illegal cannabis. Our hope is that kind of starts to dovetail into a greater operation on combating the illicit market. I'll just add one more thing, Chair, and I know I'm long-winded here, but this market study will be very important for us because as we sit here today, we don't know how big the illicit market is. Most states don't. It's very hard to figure out, especially with a lot of the tourism that we see will make it even extra harder for us to figure out exactly how big that illicit market is. But we need to know that first before we can start to address it and see if we're being effective or not.
Thank you. Next question from Assemblyman Orlicker.
Thank you, Chair, and thank you for the presentation and your service. That 150 million or so you mentioned that goes to education, which is great. Do you know how that compares to projections at the time this was debated and adopted?
Assemblyman Tyler Klimas, for the record, that's a great question. I don't know. So that would have been, predates me, that would have been in 2017, I guess. So I don't know what the projections were then. I do know, again, that we've seen, 30% growth year over year in taxable sales, and that includes taxable wholesale transactions, and then 50% in the pandemic year. So whatever they projected, I guess, I think we've exceeded that. But again, because of that, it was a little bit artificially inflated how much it grew, and now we're coming back a little bit. So that was didn't answer your question at all, but there's some extra context in there for you.
Okay. Thank you for your question, and thank you for that response. With that, we have a question from Assemblywoman Hanson.
Thank you, Chair. Good morning, and it's good to see you in person. Nice to have everyone in the building. Could you just explain what Delta 8 THC is and what the concerns are about it?
Absolutely, and I'll gladly hand that over to our resident scientist, Chief Cronkite, who heads up audit inspections for the CCP.
Good morning. Thank you for the question, Assemblywoman Hanson. My name is Kara Cronkite, for the record. My last name is Cronkhite. Delta 8 THC is a very similar molecule to what causes psychoactive effects in cannabis. So that what you normally would consume would be Delta 9 THC. Delta 8 is almost the same. It's just a carbon molecule. It's connected at a different spot, basically. It's made synthetically. So what they do is they take CBD typically, and they mix it with an acid catalyst, and that converts CBD into a psychoactive substance, being Delta 8. So these are synthetic cannabinoids. There's been several reports of people becoming very ill from consuming them, and we do not know what those byproducts produced during that conversion are.
And to add some context to that, so these Delta 8 products are being created not in our licensed cannabis establishment. This is outside of our licensed cannabis establishment. You can go on Amazon right now on your computer and order highly concentrated Delta 8 products, and it'll be at your door tomorrow, and we have no idea what's in them, and they haven't been regulated. We addressed it as a state, and I think we're in a very good position because of it last session when we made it illegal to produce synthetic cannabinoids unless it's approved by the CCB. But again, as long as there's an online marketplace that exists like it does now, impossible to enforce that.
Thank you for that. Our next question is from Assemblywoman Newby.
Thank you, Madam Chairwoman. Good morning. Back in your discussion of the transfers of interest, I was wondering, in your experience, only because I was tangentially involved in the Clark County process for the licenses, and I remember a lot of those licenses going to in-state, local Nevadans. And I have heard since that a lot of those licenses or ownership has since changed to corporations located outside of Nevada, and that the Nevadan base of ownership has really shrunk. In your experience with these transfers, is that correct, or how much has it transferred away from Nevada-based ownership?
Thank you, Assemblywoman, for the question. Tyler Klimas for the record. I think that's pretty accurate. So we're seeing nationwide and in Nevada a lot of consolidation, so a lot of acquisition. We have quite a few publicly traded companies in Nevada. We get more through the year, or we've had more through the last couple of years. So these are multi-state operators. They have operations in many states. It seems the last year or two, trying to predict federal legalization, these PTCs, they're just in a massive kind of acquisition posture. They're trying to buy up as many licenses as they can. So we have a lot of PTCs in the state. We've had a lot of our Nevada licensees sell to these organizations. We're starting to see, at the last board meeting, for example, I think out of the 5 transfers of interest that we had a PTC purchase a couple licenses. We had an investment fund from Colorado come in and buy a cultivation and production only. So we're seeing that pretty consistently.
Thank you. I'll hold my comment, but which I think is probably consistent across the dais right now. We have a question from Assemblywoman Hardy.
Thank you, Chair, and thank you for being here and sharing with us. This is, as you said, the last few years been quite interesting to learn about all of this as it's grown and become more a part of Nevada. And so my questions segue kind of from my colleagues' questions about licensing. As you discussed, some of the challenges these operators have, decrease in revenue, the illicit market and such. Do you anticipate, or are you seeing fewer applications for licensees now in Nevada? Like, how do you see that? Do you think it'll increase, or people will continue to apply, or not?
Thank you for the question, Assemblywoman. Tyler Klimas for the record. So maybe to answer your second question first, just on the health of the market, I mean, we're still seeing a ton of investment. Cannabis is still thought to be a very lucrative industry, again, across the nation. And back to those examples of who we saw come in and purchase licenses last month. I mean, these are well-capitalized funds, companies that are coming in. They're not coming in to lose money. So they obviously see that there's still a huge economic benefit here. And these are also, just generally speaking, the dispensaries are the money makers in Nevada and in most places. We're seeing investment even into cultivation and production only facilities. So again, obviously they see some benefit in there. As far as new applicants, so we haven't had consumption lounges, which we facilitated that licensing round for 20 licenses at the end of last year. That's been the first licensing round in Nevada since 2018. We have not added any cultivation facilities, production facilities. Dispensaries are capped in state law. So I think if we were to open them up, I think we would get a lot of applicants. We had over 100 applicants for the consumption lounge process. And again, that was a non-refundable application fee, and you were not going to be guaranteed the license. You had to put up that money and then enter that randomized drawing. So again, we still saw quite a few people apply for those. But I think the market study that I mentioned is something I think we all need collectively as a state to have before we make a decision to say, let's have more cultivation production licenses. What we don't want to do is upset the supply demand balance. You see some states like Oregon, California have this overabundance of product. They're bursting at the seams, and so we want to try to avoid that.
Thank you for your question, Assemblywoman. Our next question is from Assemblywoman Gallant.
Thank you, Chair. Hi, good morning. Thank you for your presentation. I'm curious, are the cannabis establishments getting better in terms of compliancy? So are you seeing a decrease in fines from year to year, or are you seeing an increase?
We still see pretty significant compliance issues. I like to think that we are beginning to weed out, and these are not intentional puns, but we're starting to get out the folks that this industry is just simply not right for them. And so we're moving towards a place where we can put our resources or direct our resources on those that are non-compliant. And we're seeing our facilities that do focus on compliance, they take compliance seriously, they build compliance into their operating procedures, really rise to the top here. And we're starting to see where our buckets are after 2.5 years. But again, in the last month, if you have seen in the press, we had a facility, utilize an unapproved pesticide that affected, 8,000 pounds of product in the state. We showed up to a facility that we eventually had to suspend, and we knocked on the door, and they opened the back door, and 6 people ran out the back. They started hiding plants in the attic and under boxes. It's all on video because you have to have surveillance. So those are really little things, that if you're focusing on compliance and it matters to you, you're not doing that. But, when I see it again in 2 months, I'll have more examples. So we're still seeing it, but again, that's why I tried to provide some of those statistics, that our audits and inspections that go out there, that we're seeing, roughly half have clean audits and inspections. I hope next biennium we're reporting on a greater number than we did this session.
Thank you. Vice Chair Marzola has a question.
Thank you, Chair, and thank you for the presentation. My question has to do with the consumption lounges. I know that 20 licenses were given, correct? How many actually applied?
Assemblywoman, thank you for the question. Tyler Klimas for the record. We had 99 completed applications for the 20 licenses available.
And follow up.
Yes, please.
Thank you, Chair. Do you know when the second round's going to be? Because I believe you're allowed 40, correct?
So we are allowed 40, but 20 of those, so we are going to have 40, I guess, so let me explain. So 20 are retail attached. That wasn't a competitive licensing round, so any dispensary, even if they had multiple dispensaries, they had the opportunity to have one consumption lounge. Could have been 40, 50 applied. 20 of our dispensaries paid the $100,000 fee and got a consumption lounge license. And then we had that randomized drawing for the other 20, which we had 99 applicants for those 20 independent lounge licenses. So we will start the lounge program with 40 originally.
Thank you. Thank you, Chair.
Thank you. And with that, not seeing any additional questions from members, I'd like to thank you for your presentation. So thank you for that. And again, members always know they can reach out to you if they have any additional questions. Thank you so much. The next item on our agenda is public comment. So if there's anyone here in the room in Carson City that would like to approach to provide public comment on something that's under the purview of this committee, you will have 2 minutes. We actually don't have connection with Las Vegas right now, but of course our phone lines are open. So our phone number is, if you wish to call in for public comment, is 1-669-900-6833. And the meeting ID or member ID number is, this is a long one, 875-825-88980. Again, that is 875-825-88980. So we'll give the public a few moments to call in. I don't see anyone here approaching in Carson City. So broadcasting, please open the lines for our first caller.
One moment, Chair.
Good morning, Anne Marie Grant for the record. My brother Thomas Purdy was 38 years old when he was murdered by Reno police on October 8, 2015 during a mental health crisis. He was hogtied for over 40 minutes and asphyxiated to death. Since the last legislative session began in 2021, 47 human beings, somebody's loved one, have died during interactions with police in Nevada. 438 since the year 2000. One victim I did not get to speak on last session was 5-year-old Soraya Shepard, who was killed when police initiated a reckless, deadly chase on 4/28/21, which resulted in the vehicle Soraya and her mother were traveling in being hit by the suspect being chased and killing Soraya. This is in a county that has 2 helicopters, by the way. Soraya was a lively, loving 5-year-old. She had a beautiful pink dress ready for her pageant, but she never got that chance to show off her smile. Instead of wearing her sparkling pink and purple dress on stage, she wore it during her own funeral. She was also buried with a crown and pink and purple roses, her favorite colors. A lawsuit was filed, and rightfully so. According to her mother's complaint, RPD and Sparks PD violated their own department policies on vehicle pursuits, which was conducted after the suspect was identified and there was no immediate threat to human safety if he was not immediately apprehended. The pursuit was also conducted in an area with heavy vehicular and pedestrian traffic and created a clear and unreasonable danger to human lives, the complaint said. The complaint also alleges that RPD and SPD had the responsibility to investigate, employ, train, and properly supervise its officers, but failed to do so, resulting in Soraya's death and her mother's constant, never-ending suffering. Records show that Judge Scott Freeman of the 2nd Judicial Court in Washoe County did not hear the argument and dismissed the complaint on April 15th, and the appeal was dismissed 10/24 by Nevada Supreme Court Justices Hardesty, Stiglitz, and Herndon for lack of jurisdiction. The city of Sparks was fighting another lawsuit that was filed by a grieving family.
Ma'am?
His loved one was killed as a result of a police pursuit.
Ma'am,
I hope
I'm
that
gonna
the
need
reform will
to,
not be a
excuse
fleeting
me, ma'am.
topic in the legislative
Okay, we'll go to our
not
next
much-
caller, please.
If you would like to provide public comment, please press *9 now to take your place in the queue. Chair, the public line is open and working. However, there are no callers wishing to participate at this time. Oh, 1 second.
Good morning. Tanya Brown, advocates for the inmates and the innocent. Tanya Brown spells TONJABROWN. Thank you, Chair and members of the Assembly Judiciary. And we'd like to also thank the presenters by the Department of Indigent Services. Well done. This has been Indigent Services. They have been before the legislature over a number of years, but I will tell you, over the last several decades, this has been an ongoing issue. And then the question was asked, why do public defenders, it's hard keeping public defenders. They also touched on that as well. But I will say that it's true, they are underpaid, they are overworked, they are not provided the amount of funding that they should be given to do a complete investigation. They've complained about investigators. They lack investigators to go out and do their jobs. Therefore, they're not able to provide an adequate defense. Sometimes they just feel defeated. And then traveling was an issue, and it still is to this day. I think maybe if you perhaps provide some type of an incentive for some of these public defenders to go out to these rural counties, such as perhaps free housing, maybe getting some new public defenders in by offering maybe to pay down a little bit on their student loans. You've got to give them something, because really they don't want to travel to Ely or Gabbs and these rural counties. Investigations, the investigators was really crucial in some of the discussions over the last few decades. Sometimes they're not allowed to go and investigate certain things because they don't have the funding or the monies to pay for them.
Ms. Brown?
They also
Ms.
have-
Brown?
Yes,
That was your time?
yes. Okay.
Thank you so much. I know
Y'all have
you.
a good day.
Yes, you too. Thank you, Ms. Brown.
Thank you.
Broadcasting, is there anyone else on the lines?
Chair, the public line is open and working. However, we do not have any other callers at this time.
Okay, thank you. Not seeing anyone approach here in Carson City, I will go ahead and close public comment. Just to let everyone know, tomorrow we will have 3 presentations. We have a presentation from Clark and Washoe County offices of the District Attorney, an overview of the State Board of Parole Commissioners, and an overview of the Department of Public Safety. With that, we are scheduled for 8 a.m. tomorrow morning. I thank all the members for their engagement and questions, and this meeting is adjourned.